I'd like to get started, ladies and gentlemen. As you know, we are a few moments late, for which I apologize. We do try to get started on time, but the traffic was particularly bad this morning, and I wanted to make sure as many registrants as possible could be here. I am Laurel Evans. I'm a planning lawyer with the Law Society's Continuing Legal Education Department, and I'd like to welcome you here this morning to the program Advising Your Corporate Clientele in a Global Marketplace. I'd like to begin by taking this opportunity to thank today's faculty, not all of whom are visibly present here this morning, not only for coming here to speak to you today, but also for the time and the effort that they have put into preparing the materials which are being presented and the papers that are in the binders that you have. I hope that you will find them useful. I'd like to introduce to you the chair of today's program, Stephen Hartley. Stephen is a partner with the law firm of Kaiser, Mason, Ball & Lewis in Mississauga. He graduated from the Faculty of Law, University of Western Ontario in 1981 and was admitted to the bar in 1983. He practices corporate and commercial law with a particular emphasis on private international business law. Mr. Hartley acts as Canadian counsel to a number of United States and European business interests in Canada, as well as many Canadian businesses with interests in foreign jurisdictions. Stephen is presently chairman of the Canadian Bar Association Ontario International Law Section, and he's a member of the International Bar Association, the Canada-U.S. Business Association, and the Canadian Exporters Association. So with that said, I'd like to introduce to you Stephen Hartley. Thank
you. Thank you very much, Laurel. Well, welcome this morning to our program on international law. I hope you had an easier time getting here than I did. I don't know how people do that on a regular basis. Practicing in Mississauga, I have the pleasure of about a 15-minute drive into work, and it's very leisurely. But getting on the highway coming down here every day, I think it's just unbelievable. I'd like to begin by saying how delighted I am to be chairing this program. Private international law has become an area of vast interest to corporate commercial lawyers, primarily client-driven. It's no secret that our economy is having its difficulties recovering, and what we're experiencing here is a jobless recovery. And it was also interesting to note last weekend that at the beginning of the meeting of the World Bank in London that they had pointed out that part of the problem with industrialized nations, as they presently are, is that the majority of investment, a new investment, is being made in emerging markets, and where there is recovery in industrialized countries, this recovery is a jobless recovery. So these are somewhat troubling times for those countries that have enjoyed good productivity growth since the Second World War, and there's all kinds of reasons for that, and I'm sure you're all aware of those reasons. But I think by practicing private international law, learning some of the skills that you need to be able to advise your corporate clients, whether they're small business, medium or large business, is that you're developing a skill set that will allow you to meet your own clients' needs, particularly in the 1990s and beyond. I really hope you enjoy yourself today. I know that these programs can be pretty dry, and I won't be offended, and I'm sure our speakers won't be offended if anybody nods off, particularly on in the two tax sections. But our tax speakers aren't here yet, so I can say that. Please don't tell them that I said that. I also hope that you learn something new today. You take that away and remember it. I typically judge a program myself, if I go, by whether there is something said that I can still recall 6 months, a year, 2 years, or 3 years later. And if I come away with something like that, then I feel that I've learned something, and hopefully it's been enjoyable. The program is wide-ranging, and I hope that the subjects that we've chosen are subjects that are relevant to your practice. We've tried to select the subject matter that we thought would most likely be applicable to the corporate commercial generalist practice. The speakers today are terrific, and just as Laurel has said, I would also like to thank those speakers in advance for agreeing to take the time out of their busy schedules to be here today. But not just taking the time today, but also taking the time to prepare the materials that you have, that you've been given. I know that that takes a great deal of effort, and it's most appreciated. Personally, I enjoy practicing private, what I call private international law as opposed to public international law, for a variety of reasons, not the least of which is I enjoy comparative law, so that you may look at one system's way of dealing with the same business risk, business slash legal issue in Canada, and you can compare how that jurisdiction legitimately believes they ought to deal with the particular issue, and compare that with the way we've dealt with it or haven't dealt with it. That enjoyment of comparative law is probably some sort of personality defect that just reflective of a banal personality generally. But secondly, the reason I enjoy private international law is you typically meet the most interesting people. I don't know how many of you like to travel, but I enjoy meeting different people and making friends of interesting people. And you do experience that when practicing private international law, whether that the individuals you're meeting are businesses on the other side of a deal, or actually other lawyers in other jurisdictions. If you enjoy cultural diversity, you enjoy practicing private international law. I can remember several years ago, just tell you just a very short story because we want to get on with our program, but I was in Italy negotiating for the purchase of a Canadian subsidiary of a bankrupt Italian company. It was a heavy machinery company, a very large heavy machinery company, and the trustee in bankruptcy was in his late 70s and was a trustee who practiced alone, as many of them do. Very much, very unlike what we have here in Ontario. And this gentleman had his office in a shabby building in some part of Torino. And we negotiated for several days. He spoke not a word of English. I was fortunate to have retained a gentleman whose name was Dr. Marco Ricolfi. He was a Harvard grad who had excellent command of English and was of Italian origin. So we discussed across the table the details of this transaction for the better part of 4 or 5 days, and it was sometimes an animated discussion. And this gentleman, in my view, was a rather stubborn individual. He had that right. It was his company that he was disposing of. But at the end of the deal, we got our deal done. At the end of the deal, he said in Italian that he wanted to toast our deal in congratulations of the transaction. And this was explained to me by Dr. Ricolfi. And he'd like to toast with vodka without any mix. So he opened his cabinet, pulled out a glass, and poured this very large tumbler of vodka, warm, no ice, sat it down in front of me, and sat down. I said to Dr. Ricolfi, is he not having a drink? He says, oh, no, he doesn't drink. He just wants to see you drink that. So, in any event, our first speaker today is Jim Klotz. He's going to talk about drafting international agreements. James M. Klotz is a partner in the Toronto firm of Klotz Associates, Barristers and Solicitors. His practice focuses primarily in international transactions. He received his LLB in 1982 from Osgoode Hall Law School. and is admitted to practice in Ontario, was admitted to practice in Ontario in 1984, and in England and Wales in 1989. Mr. Klotz is chairman of the Financing and International Law section of the Canadian Bar Association and is immediate past chairman of the International Law section of the CBAO. He is chairman Financing of International Sales Committee, which is known as M5, of the International Bar Association, and edits the international section of O'Brien's Encyclopedia of Forms. Mr. Klotz has presented papers and chaired numerous programs on international transactions in the Canadian Bar Association, the International Bar Association, New York, Wisconsin, and Michigan Bar Associations, as well as he's been an active speaker with the Canadian Institute. He teaches the negotiations and corporate law sections of the Ontario Bar Admissions course and has taught international commercial law as a visiting scholar in China. Mr. Klotz speaks Mandarin Chinese, and some of his recent papers and publications include Protection of Sellers' Rights in Canada, the UN Convention on International Sale of Goods, History and Application from a Canadian Perspective, the Legal Aspects of International Trade, and key provisions in an international joint venture agreement, a drafting guide published by the Canadian Institute. So would you please join me in welcoming Jim Klotz.
Good morning. My CV is starting to make me dizzy as well. Well, advising your client on an international transaction and drafting the resulting agreement is an intimidating task. This is because any agreement that involves a non-Canadian jurisdiction is, by its nature, instantly complex. Even if the agreement is governed by Ontario law, and even if it looks like a standard comprehensive agreement that would be useful in the domestic market, there are a bewildering set of tangential but important matters with which a comfort level has to be instantly acquired. In addition to at least one other legal system, perhaps another culture, perhaps another language, and a distance barrier, there are a legion of multinational and bilateral agreements such as GATT, quota restrictions. There are supranational treaties such as the Treaty of Rome, international conventions such as the Vienna Convention, federal government policies such as the anti-boycott policy, restrictive currency laws, sophisticated tax issues. All of these must be considered. And there are little-known criminal laws of both Canada and of foreign jurisdictions which can result in the imprisonment of your client. And this should be an undesirable result of your retainer. Generally, it's necessary to retain foreign counsel to advise on non-domestic issues. However, foreign counsel will only advise on the narrow scope of issues given to them, and thus your familiarity with the basic issues is vital. Now, my paper outlines in some detail most of the critical drafting clauses that are required for basic international agreements. For those of you who are interested in the complete agreements, they're published in O'Brien's, and I'm sure Canada Law Book would like me to give a plug for them. It's easy to make an error in this area of law. In the first few years of my practice, I blew myself up on several occasions, and it is but for sheer luck that I am still here today. Over the next few minutes, I intend to go over some of the drafting issues, problem areas of export sales, agency, and distribution agreements. My paper does deal with some of the issues of licensing agreements. I was unable to get to joint ventures, and my paper would have ended up being that thick. But in an international sales agreement, the most critical issue for lawyers today is the application of the Vienna Convention. Convention is an international set of rules which are designed to provide some sort of clarity to international sales transactions. Canada adopted it 17 months ago on May 1, 1992, and most of the Western nations, including the US, are signatories to it. The convention is important because while on the one hand it provides terms which fill gaps into a transaction, it can impose conditions which were not intended by the parties. And secondly, it can apply unwittingly when not properly excluded, as it applies generally to contracts for the sale of goods where the parties' places of business are in different countries. Essentially, since Canada is a signatory to the Convention, and since Canada has not opted out of certain provisions of the Convention, it applies to most international contracts where Canadian law applies, or where the other country is a signatory to the Convention. Thus, almost all import-export transactions between Canadian and U.S. businesses are governed by the Convention, unless the contract specifically excludes its application. Each individual sale has to be examined because the Convention does not cover some goods, and nor does it cover contracts for goods and services if service is a major component. Fortunately, the Convention does allow parties to contract out of it, but to do so, very specific wording is required. It's not sufficient to merely state that Ontario law governs the agreement, because Ontario law happens to include the Convention. Even if the Convention does apply, any of its provisions can be modified or excluded by the wording of the agreement or by industry practice, which is a dangerous area. There are a number of significant distinctions between Canadian law and the Convention. I've outlined them in my paper. But the most surprising one, at least in my mind, is the provision in the Convention that allows a seller to protect himself in the event of a fear of the credit failure of the buyer. By sending a notice, a seller can stop delivery of the goods if it becomes apparent to him that the buyer may not be able to pay. Now, in international transactions, where the buyer may be intending to flip the goods to a third party, this provision gives the seller the opportunity to absolutely ruin the buyer. Under Canadian law, the seller would not have this right unless it was specifically covered in the agreement. So when do you use or exclude this convention? Well, Ontario law, when it can be used, is much more preferable to anything and always should be. Unfortunately, Ontario law is not always acceptable to other parties. The advantage of the convention is it allows the parties a compromise over having to choose a neutral third country's laws, or the laws of a country which may not be desirable, such as those of developing countries. In those situations, the convention is an excellent resolution of that problem. Unfortunately, the bulk of Canada's business, international trade, is with the US, and there's good argument right now as to why the convention should not be used in contracts between Canadian parties and those in the US, and in other common law jurisdictions. Right now, there's not a single case in Canada on the application of the convention. Around the world, there are only, to my knowledge, 2 or 3 cases, 2 in Germany and 1 in Australia, that have even looked at portions of the convention. And so it's difficult to know how the convention is going to be either applied or interpreted by courts. But this is bound to change very shortly, because since May 1st of 1992, when Canada signed the convention, I am sure that there are literally tens of thousands of Canadian agreements which are now unwittingly subject to it. And as soon as some of those agreements roll into dispute, we're going to have lots of case law in Canada on the application of the convention. In the meantime, where the argument with a New York counsel, say, is on using Ontario law, the convention, or New York law, I would much prefer to use New York's law over the convention, particularly when I can get a New York counsel to review the agreement and advise me on exactly what it means. In reviewing the description of the goods in an export sales agreement, care must be taken to ensure that they don't require an export permit under Canada's Import and Export Permits Act. This is perhaps the singular most dangerous error that a novice exporter can make. One of our clients tried to export satellite dishes down to the Caribbean for the hotels to use so they could pick up cable TV. When he arrived at the airport, he was promptly arrested by the RCMP, the goods were destroyed, and he faced a potential imprisonment of 14 years. Under the Export and Import Permits Act, a permit is required for exports of certain types of strategic or militarily sensitive goods, which are defined on the export control list. You can get hold of the list. It's updated from time to time from External Affairs. Even if the goods aren't on the export control list, there's a second list which prohibits the exports of Canadian goods to unfriendly countries, and this is called the Area Control List. Currently, there are only 6 countries on this list: Haiti, Libya, South Africa, and Bosnia, Croatia, and Yugoslavia. In addition to Export and Import Permits Act, There is the Cultural Property Export and Import Act, which deals with the export of items which are over 50 years old. Note that the items do not have to be of Canadian origin to be caught by this act. There's also the Special Economic Measures Act, which was enacted last year, which allows the federal government to apply economic sanctions. And this was recently used by our government to keep Canadian ships from serving Haitian ports. In drafting a price clause in an agreement, it's not sufficient for the agreement to merely state the total price of the goods as well as the unit price. The contract also has to state the currency of payment. That is, whether the payment is going to be in Canadian dollars or in, say, Mexican pesos. This is particularly important on delayed delivery contracts due to the risk of exchange rate fluctuations. We have a client who last year had sales of $70 million, but suffered a $2 million loss because he failed to hedge against the US dollar. Some currencies are not convertible, such as the Nigerian kwacha or the Chinese renminbi. And when dealing with contracts with these countries, special care has to go into the pricing clause to ensure that that doesn't become a problem for the seller. Now, I heard, as an aside, something chilling just the other day, and that is the French have just introduced a new bill, banknote, on which has a magnetic strip running down the center. Now, you would think that that magnetic strip is, in fact, for an anti-counterfeit device, but in fact, it has a secondary purpose, and that is that at an airport, the metal detectors can now be modified to read the number of banknotes that an individual is carrying. So with technological advances, currency exchanges will be completely enforceable. Fundamental to determining the purchase price is the use of the customary trade terms. These have to be specified carefully. These are the CIF, FOB terms. They have to be specified carefully because they affect, frankly, the purchase price of the goods. For example, is the buyer paying for insurance and freight, or is the seller? The INCO terms, which are published by the International Chamber of Commerce, are the most widely used terms. I recommend that you get hold of a copy, although I have published printed synopses in my paper. And these terms are updated from time to time to keep track of technological advances in payment and delivery. And if you're going to use an INCO term, you better get hold of the actual text of the term and make sure you read it carefully, because in fact, a simple term like FOB means about 3 pages of INCO term and has a lot of obligations upon both buyer and seller, which catch most novices by surprise. The use of INCO terms prevails over the default rules of the Vienna Convention, but deviations are allowed simply by contracting out of them in the agreement. The time, place, and method of payment are the subject of the next speaker's presentation, but I want to mention that special care has to be taken to address all aspects of the payment documentation in the agreement. For example, some buyers in the Arab world insist upon Israeli boycott clauses in the contract. Most Canadian financial institutions will not confirm a letter of credit that contains a boycott clause. In fact, only BCC was doing so in Canada, and perhaps fortunately they're gone. As payment clauses are often related to the exporter's letter of credit arrangements, it's often useful to sit down with the exporter's banker before drafting up the agreement to make sure that the agreement reflects precisely the payment terms that the exporter has arranged or is intending to arrange through his banker. Finally, in the event that payment isn't made through a letter of credit, the agreement should provide that title does not pass to the buyer until payment has been received in full. These clauses are not tremendously useful except if accompanied by proper security, which has to be taken in each individual jurisdiction and requires a local lawyer. Am I going too fast? I'll keep moving. A force majeure clause excuses non-performance arising out of a cause beyond either party's control. Force majeure clauses are traps for the unwary in international agreements. Although such clauses appear to be boilerplate and are common, the ability of one party to rely on the unforeseen event in its own country may have a deleterious effect on the other. When used, you have to give specific consideration to the types of events that will qualify as a force majeure. and what the subsequent consequences will be. For example, where the foreign party is a government entity, such as is quite common in China, you'll want to make sure that your force majeure clause specifically excludes government acts. Often in international sales agreements, the buyer will make a request for the seller to issue a performance bond to guarantee performance of the agreement. These aren't common in Canada, they're common abroad, and they're most common in commodity deals such as transactions for the sale of steel, urea, or even wood pallets. These bonds separate the serious businessmen from the so-called agents. However, before advising your client to supply a performance bond, you should make sure that, in fact, he has spoken to his banker and can have such a bond issued in the manner in which the buyer is contemplating. Canadian banks are unfortunately surprisingly poor at facilitating international transactions in general, and special care is required for these clauses. In the event that the seller is late in performing its obligations, a penalty clause is often used to encourage attention to delivery. These clauses are sometimes enforceable, sometimes not. It depends on whether they are a realistic predetermination of damages. We have in our office right now a clause that says, an agreement says that this agreement will be governed by arbitration in Taiwan/Dallas, Texas. Damages will be 100 times actual damages. I have no idea if that's enforceable or not, and frankly, I have no idea where it's going to be enforceable. I know that arbitration is a subject for later on today, but let me talk a little bit about some of the drafting issues that go into it. Whenever there's more than one jurisdiction, arbitration clauses are often a good way of settling disputes. However, arbitration clauses are not always appropriate. For example, in Brazil, they're to be absolutely avoided. Typical arbitration clause specifies a particular arbitral association, such as the International Chamber of Commerce or the London Rules of Commercial Arbitration or the American Arbitration Institute. Unfortunately, when drafting these agreements, drafters tend to just insert a boilerplate clause, and this can lead to difficult problems. In my paper, I give almost a laughable example of a case between a Korean company and a Chinese company. The arbitration clause said that it was governed by the British Commercial Arbitration Board rules. Unfortunately, the parties were not aware that there was no such organization. The choice of the rules is quite wide. The standard ones I've just given you. There are some esoteric ones for some of the Arab countries. For China has one. Frankly, just about every country has a set of arbitration rules, including Ontario. If you're going to use a set of rules that you're not familiar with, you'd better take a look at them and see what they say. For example, a lot of Canadian contracts with China, the Chinese parties insist on using the FTAC rules, which are the local Chinese rules. Unfortunately, these rules say that any arbitrations under these rules will take place in the Chinese language, which is something you might want to explain to your client before agreeing quickly to something like that. Each arbitration body provides their own standard clause, which they recommend, and you take that clause and you modify it to suit the additional specific information that you want to have, like the number of arbitrators, the qualifications of the arbitrators, where the arbitration is going to take place, etc. It's dangerous to depart from certain aspects of the specific wording in those clauses. And for example, the courts in the US have held that the words "any dispute arising hereunder," which were found in an arbitration clause, did not include claims for fraudulent inducement of contract or quantum merit. So, frankly, attention to the developments in the law is important because most of the arbitration clauses that I've seen have those words in them. Finally, a comment on, how am I doing?
You're fine. Your time's fine.
Finally, a comment on notice provisions in agreements. These clauses require some modest amendment in an international agreement. This is because there are different business days in the foreign country, and you'll want to make sure that before you agree to business days in an Arabic country, that you're not committing yourself to periods of 30 days, which are off limits. As well, in some jurisdictions, it's prudent not to assume that a fax is received just because it's sent, and you may want to insert a requirement for verbal confirmation of faxes. And the last thing is with telex. I don't like to use telex as a means of communication because many companies have stopped using it, but they have failed to take their telex numbers off their letterhead. And so that is a danger area. In my paper, I've talked about the basic principles of agency agreements and labor issues associated with them. However, when a foreign seller, I know we're going to talk about tax later this afternoon, but when a foreign seller appoints an agent in Canada, he may be carrying on business in Canada and subject to tax in Canada, and likewise, many other countries have similar rules for carrying on business, and before an agent is appointed in some other country, some tax advice is going to be required. The definition of a sales territory in an agreement has to be considered a little more carefully in an international agreement. For example, just saying the United States it's not clear whether you've included Puerto Rico or Guam or some of the other dependencies of the U.S. And to a similar effect, the words United Kingdom, England, Great Britain, and British Isles all have different technical meanings. Generally, agents are compensated by way of commission. And in the event that a commission is to be calculated on net sales, which is generally the standard way, the agreement should specifically indicate the basis on which net sales is calculated, as in each country there will be a different legal definition of what that phrase means. The currency of compensation of the agent also has to be spelled out, and the risk of exchange rate fluctuation allocated. For example, take an agreement where the agent's commission is 5% payable in Canadian funds. Agent arranges a sale for $100,000 US, but payment by the buyer is not due for 1 year. Will the agent's fee be 5% calculated on the converted rate of US dollars at today's rate, or at the rate in 1 year's time? Caution also has to be exercised as to the location where the seller pays the agent. In the event that the agent wishes to divert its commission to a low-tax jurisdiction, which is quite common, care should be made to ensure that your client is not unwittingly violating any foreign taxing law of the agent's domicile. In some parts of the world, bribery is a way of life, and the Canadian client quickly learns that a transaction may not be completed unless he participates in this less than savory practice. This is a particularly serious problem in the emerging economies of Eastern Europe, in Africa, in South America, Southeast Asia, and China. Canadian law is somewhat lax in opposing bribery and corruption in transactions outside Canada. However, there are foreign anti-bribery laws which are territorial in scope and which should be examined. The U.S. Foreign Corrupt Practices Act is perhaps the most frightening of these. It provides rules to thwart bribery of foreign officials, and it applies to not only to U.S. citizens, but to U.S. residents and to any officer, director, employee, shareholder, or agent of a U.S. corporation which is acting on its behalf. Thus, if you're doing a transaction which involves any Americans whatsoever, the danger of getting caught by this act and its serious penalties, which include 14 years imprisonment and $1 million fines, should be looked at. In addition to the U.S., many other countries, particularly those which are developing, have similar legislation on their books, but they don't frequently enforce it. And in fact, in some countries, there is a de facto obligation for payment of commissions to intermediaries in that country. However, the client who engages in bribes in any one of these countries may find, after an abrupt change in government policy, that he or she is subject to serious criminal prosecution involving the threat of lengthy imprisonment. Even where the corruption is not criminally prescribed, the fact of the bribe may render the contract unenforceable. And in my paper, I give an instance of a recent arbitration in France where the arbitrators concluded that a commission agreement was in fact a contract for the payment of bribes by a British firm and thus was null and void. I know we're going to talk about termination of sales and agency agreements later on today. I'll just mention quickly that some countries have restrictive laws which mandate minimum termination notice periods. and in some cases minimum compensation due to the agent or distributor. For example, Belgium establishes minimum termination periods, and its law specifically supersedes the law of the contract, which is a bit of a surprise to Canadian companies doing business there. In choosing the appropriate form of intermediary, whether agent or distributorship, consideration should be given to the fact that some European countries have strong protective laws for agents, but not for distributors. Some countries have stringent labor laws which allow a terminated agent or distributor to claim from the employer the severance payments made to its own employees whose employment ended as a result of the termination. So whenever these agreements are being signed, local counsel is required. Apart from a traditional sales, representation, or agency agreement, the need may arise where an agent is engaged for a single sale on behalf of either a buyer or seller. And this relationship is more like that of a real estate agent just bringing buyer and seller together. Difficulty with these transactions in international trade is that they are always between parties who don't trust each other, and usually they involve large sums. Great care has to be required in advising on these agreements because the liability of the lawyer advising on such a transaction is not remotely commensurate with the modest amount of time or fees that can be charged. For example, I had occasion to advise on a $1.2 billion oil transaction. My client was the agent whose fee was 2%, which is about 22 million US. He had a 2-page agency agreement. He wanted 1 hour's advice. Yeah, pretty scary. Nobody likes paying commissions on these transactions, and therefore it's necessary to be specific as possible in the commission and payment clause in the agreement to avoid any opportunity for the principal to object or to delay. Often the agent will insist that the commission is wired directly into his account, and in certain types of transaction where there's a letter of credit, the agent can actually arrange to have a pay order directly out of the letter of credit proceeds on the transaction. I note in my paper that some countries regulate the activities of a broker. If your client happens to be putting together one of these transactions and is not a registered real estate broker, if you can believe, he is violating the Ontario Real Estate and Business Brokers Act, and the transaction won't be enforced. In addition, there are all sorts of brokerage laws in other countries which can nullify the agreement, and in some countries, brokerage activities carry criminal penalties, such as the laws of trading in ivory. On distribution agreements, the critical issue is antitrust. The U.S. has the most frightening antitrust legislation, and it's particularly difficult in the U.S. because the U.S. competitors of your client will rely on their regulators and their courts as business weapons against competitors. Under their laws, they can impose treble damages, and the U.S. laws have very wide extraterritorial effect. One of our clients recently tried to restrict the territory of one of its larger distributors, and we were met with one of the most chilling legal responses that I've ever seen, and certainly cause to reconsider. Europe, similarly, has antitrust legislation under the Treaty of Rome. I've given some details in my paper. All of these matters require local counsel. Am I running out of time?
3 or 4 minutes.
Okay. Well, in closing, I've skipped, unfortunately, a lot of material. I'll talk one moment about governing language. Often, the Canadian businessman will agree on a second version of the agreement to be translated into the local language of the other party. The problem is that sometimes the parties agree that both versions will be official versions of the agreement. This is dangerous, and I give an example in my paper of a recent Hong Kong-Chinese joint venture agreement. They had 2 versions of the agreement, one in Chinese and one in English. The English version referred all disputes to arbitration in Hong Kong, whereas the Chinese version referred all disputes to the FITAC in China. As far as I'm concerned, English is the governing language of international trade, and all attempts should be made to ensure that there's only one version of the agreement and that it's in the English language. And perhaps I'll stop there. Thank you.
All right,
Sir, we'd like to encourage any questions. We've got 5 minutes, so if you have any questions of Mr. Klotz, please just put up your hand or stand up or speak out. I have one comment to make about the situation with agents, particularly broker-type agents that come to your office and with a commission-type agreement, a non-disclosure type agreement. This is very common. And one of the problems, which I'm sure Jim would tell you also, is that it's very difficult to determine where the actual purchaser is. My own particular view is, as well as where the buyer is, sorry, the purchaser and where the vendor is. In other words, you'll get an agent come into your office and he'll say, broker, and he'll say, I've got this great deal I'm going to make all kinds of money on. All I've got to do is find very typical cigarettes or other types of commodities. And he'll say, I've got a buyer. And the guy is solid, and I've got a supplier of the product. And so I'd just like you to ensure that, once I disclose my supplier to this buyer, that they don't deal direct, etc. Inevitably, these people are not dealing with a buyer, but they're dealing with another agent. And they're not dealing with the actual vendor, but they're dealing with an agent of the vendor. And how many agents beyond that, you have no idea. They almost never work. Your client almost never gets his deal. And I don't, every case, of course, has to be looked at on its own merits, but I would suggest to you that I wouldn't spend a whole lot of legal time preparing an ironclad commission agreement to submit an account to this poor fellow or lady who's had this great idea, only to find that they've got a bill for several thousands of dollars or more, and they never had a deal, and they really are reluctant to pay you. The scary part, as Jim has said, is that usually the numbers that they're talking about are huge numbers, so there's a great liability, of course, on counsel to, a great responsibility on counsel to ensure that the commission agreement and non-disclosure agreement is adequately prepared. But as I say, in my experience, they almost never work, and it's just basically a mug's game. Now, I'm not saying that business isn't done that way, but in each case does have to be looked at on its merits. But nevertheless, I just caution you on that.
I've had occasion to see a full circle where the goods, there's only one set of goods, and they have gone all the way around such that they're being offered back to the guy who's got them for sale by this group of agents. I have a rule of thumb, which is where there are more than two agents, the likelihood of the transaction occurring is 0. And that's been my experience.
Question over here. Sir?
How do you convince mid-market clients that after you've had a discussion with them and outlined these various risks, how do you advise them, or more appropriately, how do you answer their questions when they say to you, how likely are these risks to arise, and to what degree do I really need protection from the Vienna Convention or any other of the matters that you've raised?
In my experience, the clients who come to us from one end of the practice are all the exceptions, the people who've gotten caught. That's on the litigious side. And so my feeling is particularly with some of these things which are really quite frightening, are that the likelihood of you, Mr. Client, being caught is high just because I believe in Murphy's Law. There's no other way of getting around it.
I think, sorry, do I understand your question to be, geez, once you sit down with your client and explain to him in 20 minutes of all the sort of risks involved, he or she's going to look at you and say, well, why would I bother looking at that, or I'm not interested in that marketplace any longer? Is that?
No, I was thinking of a situation where Jim gives his lecture, the one that he just gave to the client, and 25 minutes later the client says, well, it's interesting and it's scary, but will you assess the risk for me?
Oh, sure.
There are no cases.
Oh, sure.
No cases on the Vienna Convention.
Right.
There's only 2.
Well, we opt out of the convention. Always. So that's 10 seconds of discussion. In fact, I don't even give them discussion. We just opt out of it automatically at the moment. And that's a contentious contentious position, that's the position that our firm takes. Most of these issues are fairly straightforward and don't require the client to be taking a risk. If a client says, I'm going to China with a suitcase load of money to pay bribes, we say, don't do it. That's, you're going to be in prison in China because you're going to be the one guy who's there the day they decide to crack down on corruption. And so it's, they don't get scared. I mean, generally, they're walking in with an idea that they want to go abroad, and these are simply guidelines as to staying out of trouble.
Sir, I'm sorry. Go ahead.
One example you gave of the Vienna Convention applying was a subsidiary, a Canadian sub of a Japanese company dealing with Canadian companies. And that's really surprised me. So that it seems like we have to investigate the parentage of whatever company our client is dealing with, and if it happens to be a sub of certain a company in certain foreign countries, then you have to exclude the Vienna Convention even in a domestic context.
Our standard agreements exclude the Vienna Convention, always. Even in domestic agreements, we exclude it. We just don't take any chances with choice of law clauses right now. Thereafter, once there is some familiarity with the convention, yeah, an investigation is going to be required, unless you want the convention to apply. I mean, you know, that may be advantageous. It does do some good things in certain cases. If I was involved in a transaction with a Nigerian company and the Nigerians were unwilling to accept Canadian law, the convention's probably a better choice over Nigerian law. Yes?
Excuse me, sorry, how do you deal with the area of know-how? Very often when you're selling goods, they have know-how at the same time. And I'm not specifically referring to licensed know-how or trademarks, copyrights, patents, but just general information that a foreign buyer may want to have in connection. How do you deal with the protection of the know-how in that situation, or can you?
It depends on the, I mean, at the very least, you use a secrecy agreement to protect know-how, but the protection of know-how, of secrecy, depends on your ability to enforce it. In a foreign country, some countries, I mean, we tell clients, if you want to do business in certain countries and share with them your confidential information, you should be aware that you're probably sharing it with everybody. The only way to enforce it is through agreement. To enforce secrecy is through agreements, and the only way to enforce agreements is through legal means. And so there are places in the world you just don't want to do business if it's intellectual property that you're dealing with. Yes?
How reliable do you find the Chinese letters of credit these days, from the regional banks? And are they being confirmed or guaranteed by more reliable institutions?
I just read in, I think it's the Offshore Advisor, that banks are finding that 75% of the Chinese letters of credit are being confirmed these days. I've never had a problem with one, but that's I mean, there are lots of banks there, and I've always been dealing with the central bank, so it's those letters of credit have never been a problem.
That's the central bank, but what about the other regional banks? Any thoughts about those?
I couldn't tell you directly myself, other than this particular fact, so 75% are being confirmed. Are we getting a banker to speak? I don't think so.
But maybe that's a question for our next panelist.
My other question is, a few months ago we read about these Nigerian fraud scams. And there was a headline in the business section of the Globe and Mail, and it was a big article about it. It's happened a couple of times.
I got a letter myself, just last month.
And have many of your colleagues been getting these?
The first letter that I saw, this gentleman's talking about the Nigerian fraud letter, which is a letter which probably all of your clients will ultimately receive, since it's the biggest fraud internationally going on right now. The letter says, I am a Nigerian official with the state such and such bank. There's been an overallocation in my account of $35 million. Your name has come to me as a reliable person. I would like to share this money with you. If you can help me get it out, we'll share it 2/3, 1/3. Please send me a piece of your letterhead, blank letterhead, with your signature at the bottom of it, and I would also like your bank account number so that we can wire the funds there. Unwitting Canadians, and it's still happening today. I was just consulted on one a couple of weeks ago involving $500,000, if you can believe. And people send this. And then the Nigerians fill out on this blank piece of letterhead that's got the signature at the bottom, a letter to their bank saying, take this as my authority to wire the entire contents of my account to the Nigerian bank of such and such. And the banks do it, or at least they had been doing it. And in fact, one of my banker friends was telling me that any deal that involves Nigeria goes automatically to their fraud investigation unit. But I received one of these letters last month. The first one that I saw, just for your interest's sake though, I was retained about 4 years ago by a very, very influential person who had received one of these letters and was seriously contemplating it. I have a rule in international trade, and that is when the numbers get big, the rules tend to change. And people, even high-quality people, tend to, when they see an opportunity to have a $10 million or $20 million score, tend to drop their guard a bit. And so, I mean, I said, look, you want Interpol chasing you for the rest of your life? Yes?
I've gotten a couple of those letters myself, and I find I get them. I've gotten them twice in the last couple of years, and I've gotten them 2 days before the articles in the Globe and Mail come out, and it seems like there's a flurry of them or something, and then within 2 days or 3 days, the Globe and Mail writes about this. Well, I don't disclose them to anybody. I keep them to myself and just I've ignored them today.
The editor of the Globe and Mail probably
I'm just
gets
wondering
it.
if anybody else has been getting them.
I've seen 30 or 40 of them. And usually it's clients calling up and say, I've got this great opportunity. Is it real? And it's easy to answer. It's a good story.
All right.
Sorry, I'm out of time.
Close up. Thank you very much, Jim. Our next topic will be financing arrangements and security for payment. And our next speaker is Herman Wilton-Siegel. Herman Wilton-Siegel is a partner in the Toronto law firm of Torrey, Delorier, and Binnington, where he carries on a broad practice in corporate finance with emphasis on banking, securities, mergers and acquisitions, and trade-related transactions. In addition to practicing law, Mr. Wilton-Siegel taught for several years in the bar admission course, and for a period was the policy advisor to the Minister of Financial Institutions for Ontario. Mr. Wilton-Siegel received his legal education at Oxford, Dalhousie Law School, and Harvard Law School. Would you please join me in welcoming Mr. Herman Wilton-Siegel?
Thanks, Stephen. First of all, I want to make sure that this works. It does. Secondly, I want to say what is rather obvious. I've exercised the option to sit down rather than lecture. I had too many lectures in this room at an earlier time in my career. Thirdly, let me just check before we go, because I know we started late and we're running pretty close to what would have been the coffee hour. How long would you like me to go?
25 minutes and then 5 minutes for questions.
Okay, fine.
I'll shorten. I'm going to speak later, and I'll shorten mine.
Good.
To 5.
Well, let me try and summarize very quickly what I've dealt with in somewhat greater length in the paper. The subject of my presentation is really 4 different types of instruments which can be taken or used by parties to international transactions to secure payment or performance obligations in respect of the underlying transaction. The principal part of the paper deals with letters of credit, as that, of course, is the principal instrument used by parties today. But I also touch on performance guarantees, also issued by banks, surety bonds, typically issued by bonding or insurance companies, and letters of comfort. There's also a brief section which deals with managing foreign currency exposure, a sort of very simple introduction to hedging questions. And the paper concludes with some practical observations, principally related to the 4 types of instruments that I just mentioned, practical observations relating to negotiating the terms of those instruments or other arrangements. Okay, letters of credit. I think it's self-evident that letters of credit are the most important means of securing payment in international transactions. A very brief summary. Letter of credit is basically a written undertaking by an issuing bank to pay a sum of money to a beneficiary named in the letter of credit when certain terms and conditions have been fulfilled by the beneficiary, typically the presentation of documentation stipulated in the letter of credit. Once the conditions have been met, it's the issuing bank's responsibility to pay the beneficiary, most importantly, regardless of the applicant's wishes, except in very limited circumstances, which I'll discuss in a moment. In other words, and this is, if you take away only one principle from this discussion, the important point is that the letter of credit is to be honored by the issuing bank regardless of performance of the underlying contract between the applicant and the beneficiary, except in very limited circumstances. In international transactions, the point of the letter of credit is to ensure that from the seller's point of view, it receives a commitment of an issuing bank and thereby assurance of payment, provided it satisfies certain conditions in the letter of credit relating to presentation of documentation. In other words, it doesn't lose the goods at a point when its only claim becomes a claim for damages in another jurisdiction. Similarly, the buyer, for his part, or its part, pays in advance of actual receipt of the goods, but upon receipt of documentation which in effect evidences title. Very quickly in the paper I mentioned that the International Chamber of Commerce for years has published a set of standard terms and conditions. They do not represent the force of law, but typically they are incorporated by the parties into letters of credit. The current version is publication number 400, but as of the beginning of the coming year, a new version, as these things are revised every 10 years, so publication 500 will come into play. If you're in this business, you should make sure that you've got copies of both sets at your disposal. Types of letters of credit, two superficially similar, fundamentally very different types of letters of credit to be borne in mind. The first, typically used in international transactions, is the documentary letter of credit, which requires submission of documentation satisfying the terms and conditions in the letter of credit itself in order to avail oneself of or to become entitled to a draw. That is the form that you typically see in a transaction involving a sale of goods. A standby letter of credit, in fact, deals not with performance, but provides a backup for payment in the event of default. It evolved in the United States as a means of avoiding prohibitions under legislation that otherwise prohibited bank guarantees. The standby letter of credit, which you also see in a great many domestic transactions, including, of course, an increasing number of financing transactions, permits an applicant, a beneficiary, to draw in the event that it can assert non-payment or performance by the applicant. That's typically evidenced by mere delivery of an executed certificate or some other form of statement to that effect, together with the draw request by the beneficiary. Proof of default itself is rarely required by the terms of the letter of credit. Letters of credit can be revocable or irrevocable under the new international terms, the publication 500. In the absence of evidence of a statement to the contrary, a letter of credit will be deemed to be irrevocable. So some of the risk associated with that point is now to be removed. But acting for a client, you should ensure that you know what the terms are. If there's any indication that the letter of credit is to be revocable, make sure that your client is satisfied with those conditions well before the time in which it presents documentation for payment. Most importantly, letters of credit can be confirmed or unconfirmed. A confirmed letter of credit, which was discussed by the first speaker as well, and one or two of the questions, involves a separate undertaking by the confirming bank to make payment to the beneficiary upon satisfaction of the terms and conditions in the letter of credit. The reasons for negotiating for a confirmed letter of credit, of course, are maybe twofold. If the beneficiary is uncomfortable about the credit of the issuing bank, perhaps the issuing bank is in another jurisdiction, or it's a bank with which the beneficiary has no continuing relationship and some concerns about its creditworthiness, confirmation simply adds another undertaking, presumably by an institution with which the beneficiary has some greater, has some relationship and some higher comfort level. Secondly, it may be available in situations where the issuing bank has no paying office in the jurisdiction in which the beneficiary resides, and so it's a means of perhaps ensuring easier mechanic of payment. Negotiation credits, as opposed to straight credits, are credits under which the beneficiary is entitled to present a draft which in turn can be negotiated, that's to say sold to some third party, often another bank, but it could be an entirely separate individual, and that raises questions if you have that right in a letter of credit of holders of in due course without notice. More about that very quickly in a second. Transferable letters of credit, again, a very important concept in a sale of goods transaction. Basically, a transferable letter of credit is a letter of credit which entitles the holder to transfer not merely the right to proceeds, but in effect the right to avail himself of all of the benefits of the letter of credit. So that if the initial beneficiary does not propose himself or itself to perform the contract, but instead proposes to sell it to a third party, it can sell the letter of credit at the same time, thereby ensuring that the purchaser of that contract or of that portion of the contract in a sales situation stands in exactly the same position as the original beneficiary. Assignment of proceeds is simply to make the point that if monies at some stage become due and payable under a letter of credit because the beneficiary has satisfied its obligations, the letter of credit, the benefit of those proceeds can also be assigned. Judicial treatment of letters of credit in Canada. To summarize very quickly, there are two principles to be borne in mind, and one important case that, if you read only one case, is the case you should read. The two principles are the autonomy principle, which provides that performance of the obligations of the issuing bank under the letter of credit is independent of performance of the underlying contract. In other words, if the conditions set out in the letter of credit have been satisfied, the bank has to honor the letter of credit and pay the monies owing under it, irrespective of the fact that there may have been non-performance or alleged non-performance of the contract between the buyer and the seller. Strict compliance principle is the principle that requires that documents submitted by the beneficiary with the draw request pursuant to the provisions of the letter of credit be strictly in conformity with the conditions and the terms of the letter of credit. The case to read is the Angelica Whiteware case, because not because it deals with a very complicated fact situation, which I propose not to bore you with, but rather because it is a good example of the application of both principles, as well as an exposition of two or three points that are critical from a lawyer's perspective in terms of understanding the operation of those two principles. With respect to the autonomy principle, the court, in running through the cases, identified three circumstances which represent exceptions to the autonomy principle. The most important is fraud by the beneficiary, which is sufficiently brought to the attention of the bank by the customer before payment of the draft, and we'll get to that in a second. And this typically is where, I guess as lawyers, you get involved at one of two stages. If you're lucky, that I suppose means generally if you're involved in a large enough transaction, you may well become involved at the stage of negotiating the letter of credit. You should, and there are some practical observations I will make about that in a moment, but the general principle there is, like anything else, you should sit down with your customer and ask him what's critical in terms of being satisfied that he will get what he thinks he's bargained for, and then reduce that to the required conditions that the beneficiary must satisfy in the letter of credit. Typically, the clients go off and they negotiate these things without you. And the first you hear of the existence of a letter of credit is a panic call from the client saying, the beneficiary proposes to make a draw, how do I prevent this? Normally his presentation of the issues is somewhat more emotive if he's panic-stricken. Or you get a call from the beneficiary saying, time's running out, this whole thing's a goddamn mess, pardon my language, and I want to draw, can I draw, how do I do it, what's my situation? Or the bank, of course, calls being in the middle, anticipating that this is going to happen. Well, your advice is going to relate entirely to the application, in most cases, to the application of the fraud principle and the standard of proof that's required in order to justify non-payment. The court made it clear, first of all, that in examining the issue of fraud, the fraud exception is not limited to fraud on the face of the documentation which is actually tendered. You can examine or consider allegations of fraud in the underlying contract. It's to say that will justify the issuing bank in refusing to make payment under the letter of credit. But then comes into play the all-important question of standard of proof. And the standard of proof depends upon the stage in the proceedings. If the issue is raised in connection with an application for an injunction restraining payment of the letter of credit by the bank at the point of a draw request, the standard of proof in Canada is a strong prima facie case. If, however, the bank has not had that issue drawn to its attention, I'm sorry, let me put it another way. If, however, the application arises in connection with a denial by the applicant of its obligation, which would otherwise exist in the indemnification arrangements between itself and the bank, at the point where the applicant is being required to indemnify the bank, which has already paid, the test is more stringent. At that stage, the applicant must demonstrate that the fraud was established to the knowledge of the issuing bank before payment of the draft, to the standard of a clear or obvious fraud. In other words, the standard is a much higher one at that stage. From that, you can quickly conclude that the customer has to assemble his facts of fraud quickly and be able to demonstrate it to the point of a strong prima facie case at the point where the draw request is being made. Otherwise, it really becomes extremely difficult. I would say as well that it is always an uphill battle because there is an inherent predisposition on the part of the courts to uphold what they would perceive to be the integrity of the Canadian banking system and documentation such as letters of credit issued by it. So you will find that in the absence of clear evidence of the existence of a fraud, court will require that will deny the injunction and leave the parties to resolving the issue between themselves in terms of actions on the underlying contract itself. With respect to the strict compliance principle, I make only one or 2 points. There is some latitude in the cases upon which one can rely in terms of minor variations. But again, courts are inclined to interpret this very strictly in order to uphold letters of credit. The Angelica Whiteware case makes it very clear that they will, on the other hand, permit reliance on a defect even if the applicant is not actually prejudiced by the defect in the documentation, and indeed whether or not the underlying contract has been performed by the beneficiary. In the Angelica Whiteware case, for example, there was a question about shipment to Montreal, which was to have been expressed in the documentation. It wasn't. Notwithstanding that, the beneficiary ensured at its own expense that the goods were shipped to Montreal. That was enough, however, to permit the non-payment on the letter of credit. What that says as a practical matter to anybody involved in sale of goods in areas where the value of those goods will fluctuate dramatically is that you should be very specific in determining or in drawing the letter of credit so as to ensure that there are no provisions in that letter of credit that will allow the other party to get out of the transaction if the value of the goods shifts in a manner adverse to it. Okay, quickly, I deal in the paper with performance guarantees. Performance guarantees are basically just agreements to pay on demand issued by banks. They are an alternative in other parts of the world to standby letters of credit, and courts have adopted the view that the same principles as operate with respect to letters of credit should apply to performance guarantees. In other words, they will uphold them, and having essentially just simple promises to pay upon presentation of the demand for payment, the issuing bank is obligated to pay unless the fraud exception is available. And I might say as well, these things have often been used in circumstances where the purpose seems to be to ensure payment outside of the country by way of avoidance of currency or other similar controls. So, as a practical matter, be careful if you see performance guarantees. There are a couple of examples to that effect in the paper. Let me quickly flip to surety bonds. They're a very different species. Not only are they issued by different institutions, but the legal principles which apply are very different. Surety bonds typically, as I'm sure you would know, are a North American phenomenon. They are typically issued by specialized bonding or insurance companies, and they basically represent a promise to pay in favor of a named beneficiary, subject to provisos that the obligation will cease if certain specified conditions are met. I go through a couple of different types, but tender bonds, performance bonds, maintenance bonds, and repayment bonds are typically used or seen in construction contracts. The judicial treatment, as I say, is very different from letters of credit and performance guarantees. Surety bonds are a form of guarantee agreement, and as such they're governed by the legal principles related to the law of guarantee. The principal significance of this distinction relates to the extent to which performance of the underlying contract gives rise to a defense, a right to deny or refuse payment under the guarantee. Under a surety bond, the guarantor or surety has the same full range of rights and defenses of a guarantor. In particular, payment, if performance of the contract can be established, or if it can be established that the applicant, the customer, has a good defense under the contract, the surety will have no obligation to pay funds. In addition, where the surety is obliged to make payment, it will only be liable to the extent of the damages actually caused to the beneficiary by the non-performance by the applicant of the underlying contract. Any amount in excess of actual damages, which would otherwise be permitted under the surety bond, would typically be treated as a penalty and hence unenforceable. In addition, under surety bonds, the surety typically has the ability, has the alternative to paying damages in the form of making alternative arrangements for performance of the contract. Finally, I suppose I should say that a surety can be discharged from its liability under surety bond if the if the obligee acts to the prejudice of the surety, if the beneficiary, if you will, of the bond acts to the prejudice, for example, by varying the terms of the contract, of the underlying contract, in a manner which is materially adverse to the surety without obtaining its consent. There's a recent case with which we had some involvement, the Standard Trust and MICC case, which pretty clearly establishes the legal principle that a surety bond is a form of guarantee entitling the surety to raise all of the defenses available to a guarantor. I mentioned that case. It was simply a motion for summary judgment, and so I mention it with the qualification that is expressed by Mr. Justice Adams in that case, that he did not have the benefit of testimony concerning the commercial practice associated with these types of bonds, and he said he left open the determination of the appropriate judicial treatment of the particular instrument in that case for a trial judge. The matter never went to trial, so that remains open. Letters of comfort. As opposed to the other instruments which I've mentioned, letters of comfort are typically contractual promises issued by a non-financial institution related to the party to the contract, a parent or related corporation. An extreme form is a guarantee, but in most cases, comfort letters are simply not drafted as guarantees, and the real issue here is whether or not a letter of comfort gives rise to a legal obligation at all, or is restricted to some sort of moral obligation. They can have a variety of different levels and different commitments associated with them, depending upon the circumstances, which I've tried to describe in general terms in the paper. Let me just give you, or mention, that there are two cases in the paper which illustrate two very different approaches to the question of whether or not a comfort letter in a particular situation is an enforceable obligation. In the Kleinwert-Benson case, the comfort letter given by a parent corporation in connection with the granting of a line of credit to a subsidiary read as follows: "It is our policy to ensure that the business of the subsidiary is at all times in a position to meet its liabilities to you under the above arrangements." This was a decision by an English court, and the decision was that this did not contain a binding ongoing covenant of the parent that would permit suit. It was characterized as a statement of the policy at the time, not an express promise that that policy would continue indefinitely into the future. The opposite decision was reached in obviously a different letter of credit in Banque Lambert and the Australian National Industries Limited, which is also referred to in that case. I think it's a slightly more flexible, probably more appropriate response to the context in which that letter of credit was given. But those two cases are a good example of the general principle that if your client is looking at a comfort letter as constituting an alternative means of payment, very careful attention should be paid to the drafting of that comfort letter. Managing foreign currency exposure is dealt with very quickly. The basic issue obviously being that if the client has agreed today to receive foreign currency at some stage in the future, he or it should automatically be thinking about hedging that exposure. It's not to say that they, in all circumstances, will hedge, or even that that is the most appropriate strategy. But in advising our clients, typically ask the question, what kind of arrangements are they considering? I think bankers will typically say that in looking at the aggregate enterprise of a business engaged in international trade, they want to be satisfied that hedging is in place to the extent of the costs of the enterprise. Speculation beyond that, in other words, in terms of the profits, is a matter of the sort of risk decision-making process of the client. But up to that, they would typically expect to see hedging arrangements in place. The three that are most obvious are set out in the paper, and really for most mid-market clients, they reduce, I think, to forward exchange contracts negotiated in the context of a line of credit established with their own banks. For larger clients, they may be able to take position in the futures contracts, in the futures markets, or in the option markets, depending upon their preferences. And of course, there are a great many sophisticated treasury products which are available to those clients as well by banks. Very quickly, some practical observations. Very quickly, no practical observations.
Please, take a minute.
Okay.
To do that.
We've apparently negotiated a minute. From the client's point of view, know the party they're contracting with. I mean, everything I've dealt with in the paper is very good advice for minimizing the risk of non-payment, but is no substitute for assessing the risk of non-performance in the underlying contract. And if there is a serious concern for that, the client should be revisiting the issue of the wisdom of entering into the contract in the first place. Secondly, ensure that there is a clear and legally binding underlying contract with the customer, particularly in situations where you're looking to letters of credit. Make sure that there is a binding agreement, because if a draw is made, that of course is not the end of the story. You're thrown back on that contract in terms of basic claims for damages for breach of that contract. And you want to make sure that you're able to support your claim. Similarly, in drafting the letter of credit, as I said, avoid surprises down the road by stipulating very clearly the nature of the documentation, the contents of the documentation, and any other conditions which have to be satisfied. If you're acting for a beneficiary of a letter of credit, review it at the time that you receive it very carefully. Make sure that you're satisfied with it. Don't wait to the point where it's proposed to try to make the draw requirement. Consider confirmations in circumstances where there is a concern for the foreign issuing bank. Standby letters of credit. The one comment I would make there is that there should be a requirement for a certificate representation to be delivered by the beneficiary, so as to support which of course will be turned over to the applicant. If the applicant takes the position that this was an inappropriate draw, that's to say there was performance and hence no entitlement, he or it has the ability to make that claim based on what would be perceived to be a false representation or certificate delivered by the beneficiary. Avoid performance guarantees, and as was suggested earlier by the first speaker, pay close attention to the conflicts of laws questions. If at all possible, stipulate for a Canadian law If you're dealing with a letter of credit, there's a somewhat more complicated set of principles which might come into play if you're dealing with a situation where the parties are in several different jurisdictions. I haven't touched on that, but I would advise you to look at the materials. There are papers floating around and a couple of good books on letters of credit that can give you the answers very quickly in that area.
All right.
That's it.
Thank you. Thank you very much. Are there any questions on financing? Sir?
Recommend the type of instrument which would secure performance in a situation where a client exports goods from this country in exchange for goods produced in the country of destination for export back into Canada.
It's sort of a trade situation.
Right, barter. And further complicated, to do that type of trade situation when you've got three countries involved. You trade goods from one country to another country back into Canada, but nobody trusts each other.
All right, I have a note here that says I'm supposed to repeat the question for the purpose of the video, and I think that's not possible. Do you have a comment to make? Because what I'm going to say is we're going to break, and if you'd like to talk perhaps with Herman about that particular issue, maybe he could understand a little better what you're getting at. And you could
Sure, I'd be happy to have a chat with you. It seems to me that what you're into in that situation is not so much something that secures payment, because you're not looking for a monetary payment from any of the parties, so much as a relatively sophisticated escrow arrangement by which title to the goods is to be delivered to an intermediate party, an escrow party, to be released to the other side against comparable delivery by that party of the documentary title to the goods it's shipping.
Well, it seems to me that a performance guarantee would solve the problem if it was enforceable.
Sure. The problem in general, though, with performance guarantees is if we're talking about the performance guarantee issued by a bank, is that they're typically just demands to pay money in some circumstances. And what they do is they radically alter the position of the parties at the point where a dispute arises between them, because what they do is they provide the party in whose favor that performance guarantee has been issued with a lot of leverage. He can simply say, look, if you don't see it my way, I'll get the money from the bank and we'll fight about it later. And of course he's in international transactions, typically in another jurisdiction, with a set of laws which you feel are going to work against you, and a lot of practical obstacles as well.
Any other questions? All right, what I'd like to propose, since we're running a little bit late, we're going to have a 15-minute break. Maybe we could make this sort of a 7 or 8 minute break, or, and try and be underway again in 10 minutes.